Historical development of ADR in Pakistan. Introduction. Alternative dispute resolution, ADR, in Pakistan has undergone a dynamic evolution, deeply rooted in the nation's historical, cultural, and legal fabric. From traditional dispute resolution mechanisms to the influence of British colonial rule, the post-independence era, and the contemporary adoption of modern ADR legislation, Pakistan's journey in ADR reflects a complex interplay of diverse forces. This comprehensive exploration delves into the historical development of ADR in Pakistan, tracing its roots, examining pivotal milestones, and addressing contemporary challenges and future prospects. Here's an overview of the historical development of ADR in Pakistan. Traditional dispute resolution. Pakistan's history is marked by a rich tapestry of diverse cultures and traditions, each contributing to unique forms of dispute resolution. The jirga and panchayat systems, deeply embedded in the socio-cultural milieu, represent ancient modes of resolving conflicts. The jirga, a tribal council of elders, has played a pivotal role in addressing disputes in the Pashtun tribal areas. Similarly, panchayats, composed of village elders, have been instrumental in resolving conflicts in rural communities. These traditional mechanisms, rooted in indigenous wisdom and communal values, highlight Pakistan's historical reliance on localized and community-driven approaches to conflict resolution. The jirga and panchayat systems have, to some extent, endured through the centuries, coexisting with formal legal structures. British colonial influence. The advent of British colonial rule in the Indian subcontinent significantly influenced the legal landscape of present-day Pakistan. The British introduced a formal legal system based on English law, significantly altering traditional dispute resolution mechanisms. Courts were established, and English-style adjudication became the norm. While the colonial legal system provided a structured framework, it also led to the sidelining of traditional practices. The hierarchical and formal nature of the British legal system created a divide between the judiciary and traditional dispute resolution forums. However, despite these changes, informal methods of dispute resolution persisted, especially in rural and tribal areas where traditional practices remained deeply ingrained. Post-independence era. With the creation of Pakistan in 1947, the legal system inherited from British rule continued to be the foundation of the newly established nation. The formal judicial structure remained prominent, and the legal profession operated within the contours of the inherited legal framework. Traditional dispute resolution mechanisms coexisted but often faced challenges as the modern legal system gained precedence. In the post-independence era, there was a growing realization of the limitations of the formal legal system, particularly in dealing with a backlog of cases and ensuring access to justice for all. This led to a renewed interest in exploring alternative methods of dispute resolution, aligning with the cultural and historical context of Pakistan. Introduction of modern ADR legislation. A significant turning point in Pakistan's approach to dispute resolution came with the introduction of modern ADR legislation. The Alternate Dispute Resolution Act of 2017 marked a watershed moment, providing a comprehensive legal framework for mediation, arbitration, and conciliation. This legislation aimed to streamline ADR processes, reduce the burden on formal courts, and offer litigants more flexible and efficient avenues for resolving disputes. The 2017 Act recognized the importance of ADR in alleviating the strain on the judiciary, and emphasized the need for a cultural shift towards negotiated settlements. By acknowledging the role of mediation, arbitration, and conciliation, Pakistan took a significant step towards aligning its legal system with international standards, and fostering a more diverse and accessible justice system. Institutional development. In tandem with legislative developments, institutional frameworks for ADR were established to provide support and infrastructure for alternative dispute resolution mechanisms. The Punjab Safe Cities Authority, for instance, implemented a successful mediation program to address minor offenses. This initiative not only reduced the burden on the criminal justice system, but also exemplified the potential of ADR in fostering community harmony and resolving disputes at the grassroots level. Moreover, the establishment of the Punjab ADR Centre further institutionalized ADR processes in the province. These initiatives were indicative of a broader effort to integrate ADR into the formal legal system, creating specialized centers and mechanisms to facilitate the resolution of disputes through mediation and conciliation. Promotion by the judiciary. The judiciary in Pakistan has played a crucial role in promoting and facilitating ADR mechanisms. The Supreme Court of Pakistan, recognizing the potential of ADR to provide speedy and effective justice, has consistently endorsed and encouraged the use of mediation and conciliation. Judicial support has been instrumental in mainstreaming ADR, creating awareness, and fostering a culture of negotiated settlements. For example, in the case of Faisalabad Industrial Estate Development and Management Company, FIEDMC, v. Muhammad Salim, the Lahore High Court endorsed the use of ADR and directed parties to explore mediation before proceeding with litigation. This judicial endorsement not only expedited the resolution of the dispute, but also set a precedent for the use of ADR in similar cases. Challenges and future prospects. While the strides made in integrating ADR into Pakistan's legal landscape are noteworthy, challenges persist. Awareness and acceptance of ADR methods among legal professionals, litigants, and the broader public need to be enhanced. Cultural and institutional barriers may impede the widespread adoption of ADR, and efforts are required to bridge the gap between traditional practices and modern ADR mechanisms. The potential for conflicting legal frameworks and the need for a harmonized and standardized approach to ADR across different provinces and territories pose additional challenges. Ensuring the quality and training of mediators and arbitrators is imperative for the success of ADR processes. Despite these challenges, the future of ADR in Pakistan holds considerable promise. Continued legislative support, the establishment of specialized ADR centers, and the integration of technology can enhance accessibility and efficiency. Collaborative efforts between the legal fraternity, government bodies, and civil society can contribute to a more robust ADR ecosystem. Conclusion. In conclusion, the historical development of ADR in Pakistan reflects a multifaceted journey marked by traditional practices, colonial influences, post-independence dynamics, legislative advancements, institutional development, and judicial support. The coexistence of traditional mechanisms with modern ADR legislation illustrates Pakistan's commitment to a diverse and inclusive approach to dispute resolution. As Pakistan navigates the challenges and opportunities in the jurisdiction of ADR, the nation stands at a critical juncture. The future promises a more accessible, efficient, and culturally attuned justice system, where traditional wisdom and modern legal mechanisms coalesce to meet the evolving needs of a dynamic society. Through continued commitment, collaborative efforts, and a forward-looking vision, Pakistan can shape a future where ADR becomes an integral part of the legal fabric, contributing to a more just and harmonious society.